What if I told you that right now, at this very moment, green card holders are being stopped at US airports and told their permanent resident status is gone, not because they broke any law, but because they simply didn't know about a rule change that happened in 2026? If you have a green card, what you're about to learn in the next few minutes could be the difference between keeping your American dream alive and losing everything you've worked for. Imagine boarding your flight back to the United States, excited to return home after visiting family abroad, only to be stopped at the airport and told your green card might no longer be valid. This isn't a nightmare scenario. It's becoming a reality for thousands of green card holders in 2026. A major rule change is sweeping across U.S. immigration policy right now, and if you hold a green card, what I'm about to share could save you from losing your permanent resident status forever. Stay with me because by the end of this video, you'll know exactly what's changing, who's affected, and most importantly, what you need to do right now to protect yourself. Welcome back to US Policy Brief, your trusted source for the latest and most accurate immigration updates straight from the United States. I'm Fernando, and I'm here to break down complex immigration rules into simple, actionable steps that you can use to protect your status and your future in America. If you're new here, make sure to subscribe and hit that notification bell, because immigration policies are changing faster than ever, and US Policy Brief is committed to keeping you informed every step of the way. Today, we're tackling something extremely urgent that affects millions of green card holders worldwide: the new 2026 travel restrictions that could jeopardize your permanent resident status without warning. Let's start with what's actually happening. In early 2026, U.S. Customs and Border Protection, working alongside U.S. Citizenship and Immigration Services, has implemented stricter enforcement measures regarding the continuous residence requirement for green card holders. Now you might be thinking, I've had my green card for years. I travel occasionally. What's the big deal? Here's the reality. The law has always required green card holders to maintain the United States as their primary residence, but enforcement has been inconsistent. That's changing dramatically right now. Immigration officers at ports of entry are now using advanced data analytics and tracking systems to monitor how long green card holders spend outside the United States, and they're cracking down harder than ever before. The specific rule that's causing panic among permanent residents is this: if you spend more than 6 months outside the United States in a single trip, immigration officers can presume that you've abandoned your permanent resident status. Notice I said presume. This doesn't automatically mean your green card is canceled, but it shifts the burden of proof onto you. You'll need to convince the officer that despite your extended absence, you never intended to abandon your U.S. residence. And here's where it gets even more complicated. Even if you've been making trips of less than 6 months, if the pattern of your travel suggests you're spending more time abroad than in the United States, officers can still question your intent to maintain permanent residence. What makes the 2026 changes so significant is the technology and data sharing happening behind the scenes. Immigration authorities now have access to sophisticated tracking systems that compile your entry and exit records, cross-reference them with tax filings, employment records, property ownership, and even your family's location. When you arrive at a U.S. port of entry, the officer reviewing your documents can see a comprehensive picture of your travel history and ties to the United States within seconds. This means even if you technically haven't violated the 6-month rule, if your overall pattern raises red flags, you could face intensive secondary inspection or even formal abandonment proceedings. Let me give you some real-world examples that are happening right now at airports across the country. There's a green card holder from California who used to travel to India for 4 to 5 months every year to care for aging parents. She always returned before the 6-month mark, thinking she was safe. In February 2026, when she landed at San Francisco International Airport, she was pulled into secondary inspection. The officer presented her with a detailed breakdown of her travel over the past 3 years, showing she'd spent nearly 60% of her time outside the United States. She was given the option to voluntarily surrender her green card or face formal removal proceedings. She fought the case, but it cost her thousands in legal fees and months of uncertainty. Another case involves a green card holder who works for an international company. He was required to spend extended periods in the company's Singapore office. He assumed that because his employment was with a US-based company and he paid US taxes, he'd be fine. Wrong. When he returned after an 8-month assignment, immigration officers questioned whether he truly maintained the United States as his primary home. He had kept his apartment in New York, and his car registration was current, but because he didn't have strong family ties in the U.S. and his physical presence had been minimal over 2 years, his green card was flagged for review. So, who exactly is most at risk under these new enforcement measures? First, retirees who split their time between the United States and their home countries. Many green card holders reach retirement and decide to spend extended periods abroad where the cost of living is lower or where they can be closer to family. If this is you, you're in the highest risk category right now. Second, individuals caring for sick or elderly relatives abroad. I understand the moral obligation you feel, but immigration law doesn't provide exceptions based on compassionate reasons for extended absences. Third, people who work for international companies requiring long-term foreign assignments. Even if your employer is American, if your physical work location is abroad for extended periods, you're at risk. Fourth, students who return to their home countries for education or training programs. And fifth, anyone who owns property or maintains significant business interests abroad, especially if those interests require your regular presence. Now, let's talk about what you can do to protect yourself. The single most important thing is to maintain clear, demonstrable ties to the United States. This isn't just about what you say, it's about what you can prove with documentation. Here are the key factors immigration officers evaluate. First, your physical presence in the United States. This is the most heavily weighted factor. You should be spending more than half of each year physically present in the U.S. If your job or circumstances require extended travel, you need to carefully track your days and make sure you're not creating a pattern of absence. Second, your tax status. Are you filing U.S. tax returns as a resident? Are you reporting worldwide income? Maintaining U.S. tax residency is critical evidence of your intent to keep America as your primary home. Third, employment location. Where is your actual job? If you're working abroad, even remotely for a U.S. company, this can count against you. Officers want to see that your employment ties you to the United States. Fourth, family location. Where does your immediate family live? If your spouse and children are in another country, this suggests your primary residence might not be the United States. Fifth, property ownership and financial accounts. Do you own or rent a home in the U.S.? Do you have U.S. bank accounts, credit cards, utility bills in your name? These are concrete evidence of residential ties. Sixth, community connections. Are you involved in local organizations, churches, clubs? Do you have a U.S. driver's license and vehicle registration? These details matter more than you might think. If you know you need to be outside the United States for more than 6 months but less than 1 year, there's a specific document you should apply for before you leave. It's called a re-entry permit. This is an official document issued by USCIS that allows you to remain outside the United States for up to 2 years without abandoning your permanent resident status. However, and this is crucial, you must apply for the re-entry permit while you're physically in the United States, and you must complete your biometrics appointment in the U.S. before you depart. You cannot apply for this from abroad. The re-entry permit doesn't guarantee you won't face questions when you return, but it's strong evidence that you intended to maintain your status and that you properly notified immigration authorities of your need for extended absence. Here's something many green card holders don't understand. A re-entry permit is not the same as maintaining continuous residence for naturalization purposes. If your goal is to eventually become a U.S. citizen, you still need to meet the continuous residence and physical presence requirements, which are even stricter than the requirements for maintaining your green card. For naturalization, you generally need to have been physically present in the United States for at least half of the 5-year period before applying, and you cannot have any single absence of more than 6 months, or if you do, you'll need to prove you didn't break continuous residence. This is why planning is so important. Let's address what happens if you're already outside the United States and you've been gone longer than you intended, maybe due to a family emergency, medical situation, or circumstances beyond your control. If you're approaching or have exceeded 6 months abroad, you have a few options, none of them perfect. First, you can return to the United States as soon as possible and be prepared to thoroughly explain your absence to the immigration officer at the port of entry. Bring extensive documentation showing your ties to the U.S. and the reason for your extended absence. Medical records, death certificates, letters from employers, property tax records, everything that proves your intent to maintain residence. Second, if you've been gone more than 1 year, your green card is technically no longer valid for re-entry, and you'll need to apply for a special immigrant visa called an SB-1 returning resident visa at a U.S. embassy or consulate abroad. This requires proving that your extended absence was due to circumstances beyond your control and that you always intended to return to the United States as your permanent home. The SB-1 visa process is difficult, and there's no guarantee of approval. U.S. consular officers have significant discretion in these cases, and they're looking for compelling evidence that your absence was truly unavoidable and temporary in nature. The burden of proof is entirely on you. If your SB-1 application is denied, you've essentially lost your green card, and you'd need to go through the entire immigration process again from scratch if you wanted to return to the United States as a permanent resident. Here's what U.S. Policy Brief recommends based on the current 2026 enforcement environment. First, if you're planning any trip abroad, especially one that might last more than a couple of months, document everything before you leave. Make copies of property deeds, lease agreements, tax returns, employment letters, utility bills, bank statements, and keep these documents accessible so you can present them if questioned upon return. Second, set calendar reminders to track your time outside the United States. Don't rely on your memory. Use a spreadsheet or app to log every day you're outside the country. Third, if you anticipate needing to be abroad for more than 6 months, apply for a re-entry permit before you go. The application fee is currently around $660, but that's a small price compared to losing your green card. Fourth, maintain active U.S. ties even while abroad. Keep paying your mortgage or rent. Maintain your U.S. phone number. Keep your bank accounts active. File your taxes on time. Fifth, if possible, break up long trips abroad with returns to the United States. If you need to care for a family member overseas for an extended period, try to structure your time so you're returning to the U.S. every few months rather than staying abroad continuously. Yes, this might mean more expensive airfare, but it's worth it to protect your immigration status. Sixth, consult with an immigration attorney if you have any doubts about your situation. Immigration law is complex, and individual circumstances vary significantly. What applies to one person might not apply to another. A qualified immigration attorney can review your specific situation and advise you on the best course of action. Don't wait until you're already facing problems at the port of entry. Let me also address a common misconception. Some green card holders believe that as long as they return to the United States before their green card's expiration date printed on the card, they're safe. This is completely wrong. The expiration date on your green card is simply the date when the physical card needs to be renewed. It has nothing to do with the rules about maintaining continuous residence. Your obligation to maintain the United States as your primary permanent residence exists from the day you receive your green card until the day you either become a U.S. citizen or formally abandon your permanent resident status. Another important point concerns conditional permanent residence. Those who received their green cards through marriage to a U.S. citizen and are still within the 2-year conditional period. The travel restrictions apply equally to you, but you face an additional complication. If you're outside the United States when your conditional status is about to expire, you may have difficulty filing the required petition to remove conditions. This could result in your status automatically terminating. If you're a conditional resident, it's especially important to maintain presence in the United States and carefully plan any international travel. For those of you watching from outside the United States who are considering applying for a green card, let this be a warning about the responsibilities that come with permanent residence. A green card is not a visa for unlimited international travel while maintaining a token connection to America. It's a privilege that comes with the obligation to make the United States your actual primary home. If you're not ready or able to make that commitment, a green card might not be the right immigration status for you at this time in your life. The bottom line is this: the 2026 enforcement environment is stricter than it's been in years, possibly decades. Immigration officers have better tools, more data, and clearer directives to scrutinize green card holders' compliance with residence requirements. The cases I've shared with you today are not isolated incidents. They're happening at airports and border crossings across the country every single day. Thousands of green card holders are facing unexpected challenges, and many are losing their permanent resident status because they didn't understand the rules or didn't take them seriously enough. Here at US Policy Brief, we're committed to keeping you updated on every change in immigration policy that affects your life and your family's future in the United States. The immigration landscape is shifting rapidly, and staying informed is your best protection. If this video helped you understand the new travel restrictions for green card holders, please give it a thumbs up and share it with anyone you know who has a green card or is planning to get one. Your share could save someone from making a costly mistake. Subscribe to US Policy Brief if you haven't already, and turn on notifications so you never miss critical updates like this one. Drop a comment below telling me your situation. Are you a green card holder who travels frequently? Are you worried about these new enforcement measures? Let's discuss in the comments and support each other through these changes. Remember, knowledge is power, especially when it comes to protecting your immigration status. Stay informed, stay compliant, and stay safe. My name is Fernando, this is US Policy Brief, and I'll see you in the next video with more essential immigration updates.